Afternoon, everyone. Thanks so much for being here. My congratulations to Amy and colleagues here for the new Asian American Studies program. It's very exciting, and we all need a bit of good news in this difficult political time. So I'm thrilled about the Afro-Asia theme because this is a theme that's preoccupied me for many, many years. And I really want to thank Amy and the organizers for creating this occasion for us to come together and think anew about this theme. I'm really looking forward to the conversations we will have over the next few days. So I will be speaking today about the case Students for Fair Admissions against Harvard University that's now pending in federal court in Massachusetts. Federal District Court, the first case to feature Asian American plaintiffs challenging affirmative action in higher education. How many of you have heard of the case and have been following it in the news? Oh, okay. Most of us find this case interesting. Okay, so despite getting a lot of media attention, the first portion of the trial, which wrapped earlier this month, was not all that exciting because it was pretty much dueling statistical analyses of admissions data in the court. But whatever the trial lacked as spectacle, I want to argue, it made up for in historic significance. In my view, the Harvard case is a historic turning point, maybe even a moment of crisis, not just in terms of law and policy, what will happen to affirmative action in US higher ed, it may well end because of this case, but also in terms of ideology and politics. Here I refer to the way that the case puts pressure on contemporary understandings of racial identity and racial justice, and the century-old Afro-Asian narratives upon which these are based. The Harvard case is a moment of reckoning that exposes some of the contradictions and fallacies of our current racial thinking. It is for this reason also a moment of possibility. So some facts about the case. In November 2014, a newly formed organization, Students for Fair Admissions, filed suit against Harvard in federal district court, alleging that the university discriminated against Asian Americans in undergraduate admissions, and asking the court to prohibit Harvard from considering race at all in its admissions process. In response, Harvard denied that it discriminates against Asian Americans and declared its intention to fully defend its holistic admissions program, famously praised by Justice Powell in the Bakke decision for using race as just one factor in trying to create a diverse student body. So a brief look at the rallies that accompanied the opening of the trial.
Holding signs that say "Stop Harvard's Asian Quota," a group of Asian Americans led by Edward Bloom of Students for Fair Admissions took to Copley Square to protest Harvard University's admissions process. Bloom and others are suing the famed institution for discrimination.
Harvard systematically raises the bar for Asian Americans and systematically lowers it for whites, African Americans, and Hispanics. We allege that Harvard has a quota that limits the number of Asians.
Ed Bloom, who is this man and why is he leading a lawsuit on behalf of Asian American students? Harvard's initial brief argues that Students for Fair Admissions is a shell organization created by Ed Bloom as a vehicle to advance a right-wing political agenda. This agenda is sometimes politely referred to as rolling back the race-conscious reforms of the civil rights era. But if we refuse the euphemization, what we arrive at is Ed Bloom and his right-wing colleagues want to return us to the status quo ante of Jim Crow. As a point man for the right's long-term multi-million-dollar campaign to achieve this goal, Bloom has filed more than 24 lawsuits challenging affirmative action and voting rights. His big win was Shelby County v. Holder, the 2013 case, Supreme Court case, where the court eviscerated the Voting Rights Act of 1965 by effectively disabling federal preclearance of changes to state election laws. Practices of voter purging and voter suppression have expanded in the wake of this ruling, just as we would expect, with consequences for the 2016 and 2018 elections. After the Supreme Court upheld race-conscious admissions in Fisher v. Texas, a case I'll briefly talk about later, a case that Bloom was the driving force behind, Bloom regrouped and came up with a new plan, finding Asian Americans to use in the fight against affirmative action. He formed Students for Fair Admissions. The two other board members were Abigail Fisher of Fisher v. Texas and her father, Richard Fisher, and he went looking for Asian American plaintiffs. Okay, so they formed this organization, Fisher, and Bloom. They formed a website called harvardnotfair.org, and they used photos like this to recruit Asian American students as plaintiffs. So as you can see on this picture, were you denied admission to Harvard? It may be because you're the wrong race. And then at the bottom, tell us your story. Does this mean that the right suddenly loves Asian Americans? Does it? It might be more accurate to say the right is willing to do what is necessary to maintain a negrophobic social order, even acknowledging that Asians are discriminated against and admitting more Asian students into institutions of higher education. Strikingly, the Student for Fair Admissions complaint argues not only that Asian Americans are a minority, too, but that they are the most discriminated against minority, doubly burdened by white hostility on the one hand and affirmative action programs designed to help Black people on the other. Asian Americans, the complaint suggests, have displaced Blacks as the most disadvantaged group in society. They are, in effect, the new Blacks. It is often said that Asian Americans are used as pawns by the right in affirmative action issues, but in fact, as the video clip shows, Asian Americans are standing alongside Ed Blum, front and center in the fight to dismantle Harvard's affirmative action program. The Asian American Legal Foundation, a Chinese American organization formed to bring the Brian Ho anti-affirmative action lawsuit against the San Francisco Unified School District in the 90s, along with the Political Action Committee 8020, filed a complaint with the U.S. Departments of Education and Justice charging Harvard with discrimination against Asian students. This complaint was meant to work in tandem with the lawsuit against Harvard, and the complaint quotes the Harvard brief at great length, the Students for Fair Admissions brief at great length. And by filing the complaint with the U.S. Departments of Justice and Education, they've brought the Trump administration into this legal and political battle. In addition, as I'll show, the amicus briefs submitted by the Asian American Legal Foundation in recent Supreme Court cases craft an argument about anti-Asian bias that serves as a template for the Students for Fair Admissions lawsuit against Harvard many years later. What we are witnessing is the emergence of a political phenomenon that has just begun to attract scholarly attention: the mobilization of conservative, professional, middle to upper class, first-generation Chinese Americans via Chinese language apps and social media networks into a formidable anti-affirmative action fighting force on a national scale. Although they represent only a small minority of Asian Americans, these activists claim to speak for all of them, and their dramatic confrontational rhetoric and modes of organizing have mostly drowned out the voices of the majority of Asian Americans who support affirmative action. With an unapologetic Asians first, actually Chinese first position, they scoff at the coalition building commitments embraced by Asian American activists for the past half century. It is the explosive convergence of this nascent Chinese immigrant nationalism with an older conservative white nationalism that is driving anti-affirmative action politics today. So what I want to do today is step back and trace the history of how the Harvard case came to be by looking at how Asian Americans have been figured and have figured themselves in Supreme Court jurisprudence on affirmative action in higher education, from Bakke to the present. And what I will argue is that the Student for Fair Admissions argument in the Harvard case actually culminates a logic that was first laid out in the Bakke case over 40 years ago. A logic of minority equivalency that suggests that all racialized groups, non-white racialized groups, are comparably situated. A logic that despecifies the singularity of Black abjection and disavows the foundational role that anti-Blackness has played in structuring the US social order. This logic of minority equivalency builds upon the flattening, homogenizing aspects of third world narratives, but it also puts the solidaristic aspirations of third world narratives into crisis, as Asian American plaintiffs seek to achieve greater representation at elite universities while dismantling the programs that help other non-white groups in the admissions game. If we look back at the Bakke case, 1978, with the benefit of hindsight, we can see the seeds of the Harvard case there, waiting to grow. So let's start with the memorandum for Mr. Justice Powell, authored by Justice Powell's clerk, Bob Comfort. As you can see with my little hand-drawn red circle there, Powell wrote excellent memo at the top of Comfort's memo and affirmed his clerk's arguments in extensive handwritten margin notes throughout the document, clearly indicating this memo closely shaped or reflected his views on the case. In this memo, Comfort notes that respondent, Bakke, challenging the UC Davis Medical School's affirmative action program, argues that all racial classifications, even supposedly benign ones, must be treated as suspect and trigger strict scrutiny, lest courts be faced with the impossible task of adjudicating innumerable claims of group injury. Oh, I don't expect you to be able to read that. I just wanted to show you the excellent memo part. Okay, Comfort writes, most of the ethnic groups comprised by American society have faced, and to some extent still face, prejudice and hostility. Courts will be called upon to explain why classifications disadvantaging some groups will trigger strict scrutiny, and those dealing with others will not. Principled bases for such racial distinctions, says respondent Bakke, are hard to imagine. Presumably, courts would be required to establish rankings of those groups that have been harmed the most by exclusion from various institutions. Courts have done little of this sociometric analysis in the past. So, concurring with Bakke, Comfort opines that the courts should decide matters on an individual basis rather than attempting to judge relative group suffering and desert. Sociometric analysis is beyond the court's purview because there is no principled way to make such distinctions, no objective way to ascertain who has been harmed, how much and by whom, and what is owed to them as a result. So courts should not be in the business of sociometry, except that, of course, they are. Comfort's refusal to offer a sociometry that is explicit and transparently argued simply results in his assuming by default a covert and unsubstantiated one. The judgment that there are too many comparably situated groups to adjudicate among is, after all, itself a sociometric observation. So Comfort uses a sociometric observation to argue that sociometry is impossible. In any case, his covert sociometry has a leveling, equivalencing thrust. There is no structural positionality, no foundational anti-Blackness, only fluidity, variation, complexity. Society is a cacophony of comparably situated, competing, self-interested voices. What about the petitioner, UC Regents' suggestion that courts simply begin with the obvious thing? Blacks have been disadvantaged in US society, and then go from there, and maybe they'll add a few other groups along the way. So to that idea, Comfort responds, the prejudice faced by every distinct racial and ethnic group entering this country makes each a potential candidate for compensatory legislation. Consensus as to who needs it and who should bear the burden will be lacking. Witness the nearly 60 briefs filed in this case. The attempt to separate competing claims may well confound judicial ingenuity. Benign scrutiny could be reserved, of course, for a few groups said to be harmed more than most, Blacks, Puerto Ricans, Indians, but it is not immediately clear how one draws a bright line between those groups, and say Jews or Orientals. Both of those groups faced almost hysterical prejudice for decades after first arrival in this country. Both face a quieter, subtler form of prejudice today. A decision that the prejudice facing Blacks has been quantitatively more disabling would amount to a judicial leap of faith, I think, rather than a judicial expression of social consensus. So here it is very clear. Comfort brings Orientals into the picture, along with Jews, for the specific purpose of undercutting the petitioner's suggestion that we treat Black disadvantage as a consensual departure point. Asians are spoilers here, a wrench in the works. Because Asians can make a strong case that they too have been subject to racial discrimination, Comfort argues, they pose a slippery slope problem for those trying to decide who deserves remedial consideration. So Asians get invoked to thwart the petitioner's attempted specification of Black abjection, to render Black suffering legally unrecognizable, and to throw a pluralistic tarp over the ugly topography of an anti-Black society. At times in Comfort's memo and Powell's decision, as we'll see, it's all ethnic groups that are comparably situated, including white ethnics. At times the focus is on all non-white ethnic groups, but in all cases, the experience of discrimination is universalized and Black abjection disappears in a sea of equivalences. Momentously, again, I'm just going to draw your attention to the part circled in red. Momentously, Justice Powell declared in the margins of Comfort's memo, quote, petitioner's argument that Blacks are different is not logically supportable, unquote. What about the US government's amicus brief filed in Bakke in support of the UC Davis Medical School? Here again, Asian Americans show up as a potential problem for race-conscious admissions, arguing that properly designed minority-sensitive programs are necessary to overcome the effects of years of discrimination. The brief lays out statistical evidence of discrimination against Blacks and those of Spanish heritage. In footnote 39, it then states obliquely, the figures for Asian Americans, Japanese, Chinese, and Filipino only, are somewhat different, unquote. Various figures are then provided indicating Asian Americans look closer to whites than other groups by these figures, with no accompanying commentary. Later, during a discussion of the paucity of Black and other non-white students in medical schools, footnote 51 notes, quote, there is no apparent underrepresentation of Asian American persons, unquote. Indeed, between 1970 and 1974, the total number of Asian Americans admitted to the UC Davis Medical School through general admissions was 41. The number of Black and Chicano students admitted through general admissions was 1 and 6, respectively. Asian Americans are left as a discomforting asterisk in a brief that is trying to argue in defense of affirmative action. Quote, it is not clear from the record why Asian American persons are included in the special program. In the governing decision in Bakke, Justice Powell flags Asian Americans no fewer than 3 separate times as a potentially fatal problem for affirmative action. He discusses them each time in the footnotes, which conveys a sense that Asian Americans are like secret spoilers, right? The suppressed truth of Asian Americans the suppressed truth of affirmative action waiting to be exposed. But first, before I get to those 3 mentions, a quote that shows how heavily Justice Powell's decision leans on the reasoning of Bob Comfort's memo, which we've already looked at. Okay, so this is a pretty long quote, just bear with me. Okay, the difficulties entailed in varying the level of judicial review according to a perceived preferred status of a particular racial or ethnic minority are intractable. The concepts of majority and minority necessarily reflect temporary arrangements and political judgments. As observed above, the white majority itself is composed of various minority groups, most of which can lay claim to a history of prior discrimination at the hands of the state and private individuals. Not all of these groups can receive preferential treatment and corresponding judicial tolerance of distinctions drawn in terms of race and nationality, for then the only majority left would be a new minority of white Anglo-Saxon Protestants. There is no principled basis for deciding which groups would merit heightened judicial solicitude and which would not. Courts would then be asked to evaluate the extent of the prejudice and consequent harm suffered by various minority groups. Those whose societal injury is thought to exceed some arbitrary level of tolerability would then be entitled to preferential classifications at the expense of individuals belonging to other groups. Those classifications would be free from exacting judicial scrutiny. As these preferences begin to have their desired effect and the consequences of past discrimination are undone, new judicial rankings would be necessary. The kind of variable sociological and political analysis to produce such rankings simply does not lie within the judicial competence, even if they otherwise were politically feasible and socially desirable. So like Comfort, Powell claims an objective sociometry is impossible because there are no persistent patterns of racial injury, no structures of racial domination. There is nothing to measure. Indeed, the very terms minority and majority have little purchase, he says, as the white majority is but a composite of white minorities that have each faced discrimination, and once we subtract them, the remainder, the WASPs, become, lo and behold, a new minority. So we are all minorities now. Note the sleight of hand, shifting from a racial political definition of minority to a numerical one. Powell hints at a dystopian scenario where courts would arrogate to themselves the right to choose arbitrarily which groups to favor, and then be compelled to adjust those rankings over and over again to respond to the changes wrought by their own favoritism. If courts attempt to measure a racial positionality that does not exist, Powell suggests, they will actually create it. Justice Powell's vision of intergroup relations, his sociometry that refuses to be called sociometry, is highly impactful. It directly underwrites his momentous finding that the societal discrimination petitioner claims to be redressing through affirmative action is an excessively amorphous concept of injury that does not justify the use of racial classifications. If everyone is discriminated against, no one is discriminated against, at least not in a sense that is legally actionable. The way is paved then for Powell to substantially de-link affirmative action from its original remedial rationale and thus change its purpose and trajectory forever. Okay, let's look at the 3 moments where Powell mentions Asian Americans in his decision, again, all in the footnotes, and in each case we see that he's using Asian Americans to undermine the societal discrimination rationale for affirmative action, okay? In footnote 36, Powell observes Justices Brennan, White, Marshall, and Blackmun, who all supported societal discrimination as a rationale for affirmative action. He notes that they argue that blacks would have gotten better scores absent societal discrimination. And then he writes, quote, nothing is said about Asians, unquote. We read between the lines. If Asians can get good scores and they're discriminated against, why can't Black people? In footnote 37, Justice Powell mentions the University of Washington, which includes Filipinos in its affirmative action program, but excludes the Chinese and Japanese, who are better represented. He writes here, but what standards is the court to apply when a rejected applicant of Japanese ancestry brings suit to require the University of Washington to extend the same privileges to his group? There is no Western state which can claim that it has always treated Japanese and Chinese in a fair and even-handed manner. And then finally, footnote 45. Quote, the university is unable to explain its selection of only the 4 favored groups, Negroes, Mexican Americans, American Indians, and Asians, for preferential treatment. The inclusion of the last group is especially curious in light of the substantial numbers of Asians admitted through the regular admissions process. Again, all 3 comments figure Asian Americans as disrupting the link between discrimination and underrepresentation, and thus undermine the societal discrimination rationale for affirmative action. In the end, Powell saves affirmative action by proffering diversity as an alternative rationale, right? Diversity is a compelling state interest. As long as colleges can pursue this, as long as they do not use fixed quotas. So he argues that we should strike down the UC Davis Medical School affirmative action program because it set aside a particular number of places rather than just using race as one factor in evaluating students, as Harvard did. So race-conscious admissions in higher education survives in the Bakke case, but only after it is effectively delinked from slavery, segregation, and what Saidiya Hartman calls the afterlife of slavery. Blacks and a few others can be admitted in larger numbers to U.S. institutions of higher education as long as this is not framed in terms of what is owed to them as a matter of justice, but rather in terms of what would enhance white students' abilities to thrive in a multicultural world. So what do we make of the persistent figuration of Asian Americans as spoilers in the Bakke case? Should we turn, as Asian Americans often do, to the model minority myth? Is that what is going on here? The standard critique of the model minority myth goes something like this. Asian Americans are presented as being more successful than they are in order to drive a wedge between Asians and Blacks, to divide and conquer minorities for the benefit of whites. The model minority myth is a white supremacist ideology that must be debunked. Its blanket assertion of success exaggerates Asians' socioeconomic status and conceals the fact that, in fact, Asian national origin groups vary quite widely, right, in terms of their socioeconomic measures. To sum it up, the critique of the model minority myth says Asians aren't doing all that well. Not all Asians are doing well, and Asians are minorities too. But even when we keep all of this in mind, there's still something here that seems to need explaining. Why do many Asian Americans fare better than Blacks, despite being subject to past and present discrimination? Why were Asian Americans the only minority that was admitted to UC Davis Medical School in significant numbers in the general program? Why does the discrimination underrepresentation link seem to break down with Asians? So what I want to suggest to you today is that focusing on the model minority myth as an explanation for what is going on here will actually disable us from answering these questions. This is because the critique of the model minority myth is flawed as an analysis in at least 2 ways. It reads the valorization of Asians over Blacks as merely rhetorical or discursive, and thus obscures the fact that this valorization has been enacted as social structure for nearly 2 centuries. Asians and Blacks have been assigned from the start to distinct positions in the U.S. racial order, and recognizing and naming this fact is a prerequisite for understanding differential group outcomes. The problem is not a myth that we can correct or debunk. The problem is structural positionality. The second issue, and we'll come back to this again, is that this critique reproduces the logic of minority equivalency that I've already mentioned. Okay, 20 years ago almost, in 2000, I wrote the following. The assertion of formal interminority equivalences in the face of persistent interminority differentials in status, privilege, and power facilitates the white project of using Asian Americans against Blacks. Okay, I'm going to scroll down again to, a little bit further down. After all, if we view all minorities as formal equivalents, it seems presumptively unfair that one minority group should burden another in its efforts to advance. I refer to this phenomena of automatically overriding the claims of one minority group, blacks, through reference to the moral authority of the claims of another minority group, Asian Americans, as playing the racial trump card. Okay, so this was 2000. I didn't realize the word Trump would become quite so loaded. I didn't realize that this would have come to have a double meaning, that in fact this mode of deploying Asians would intersect with the phenomenon of Trumpism. But what you can hear in my words is a concern, right, about the dynamic that I identify and which I think has come to be in the Harvard case. Writing in 2010, in an article entitled People of Color Blindness, Jared Sexton discusses a phenomenon he calls people of color blindness, which he defines as a form of colorblindness inherent to the concept of people of color, to the precise extent that it misunderstands the specificity of anti-Blackness, and presumes or insists upon the monolithic character of victimization under white supremacy. In a negrophobic society, Sexton argues, the fundamental divide is not between whites and non-whites, but rather between blacks and non-blacks, or between those whose abjection provides a foundation for the social order and those whose coherence and well-being are grounded upon that abjection. People of color, third world peoples, minorities, these are concepts that suggest equivalencies under white supremacy and to this extent obscure the way in which anti-Blackness divides and differentiates non-whites. So how should we think about the structuration of race? What kind of sociometric analysis could we pursue? These are the questions that animate my current book project, Asian Americans in an Anti-Black World. I'm going to try to take just a little slice of the book to present to you before we move on with affirmative action. Okay, so my departure point is Lewis Gordon's discussion of the two principles shaping the US racial order. Be white, but above all, don't be black. White is best, but the most important thing is not blackness. Blackness, Gordon writes, is the point from which the greatest distance must be forged. So, building upon Gordon, we can say the racial order is structured first and foremost by anti-Blackness, the abjection of blackness, and secondarily by white supremacy, the valorization of whiteness. Asian Americans, I argue in my book, are positioned at that tense conjuncture between anti-Blackness and white supremacy, where the elevating force of being not black meets the downward force of being not white. Despite significant and persistent inequalities among Asian American groups, even the worst off among them have something, in James Baldwin's words, something to lose, namely their not blackness in an anti-black society. So let me make this a little more concrete by discussing the original Asiatic in the American imagination, the Chinese immigrant laborer in the 1800s. Yes, everything always goes back to the Chinese immigrant labor, everything in Asian American studies anyhow, where we can see how not blackness was constitutive of the very concept of the Asiatic from the start. What we see in each of the three Chinese labor stories of the 19th century that I briefly touch upon in my book, Chinese wage labor in California, Chinese contract labor in the US South, Chinese indentured labor in Cuba, is that Chinese presence was always predicated on black absence. As we learned from Nadia Aram-Hario, Edley Wang, and Moon Ho Jung, Chinese migrants came to California because it was a free state that prohibited slavery and thus had an enormous demand for labor. They were transported to Cuba as part of the coolie trade that sprang up to take the place of the declining global slave trade. And they were transported into the South in the wake of the Civil War to help lock down black economic and political subordination. Global racial meanings shaped and were shaped by these global labor flows under capitalism. Both Western and Asian ethnological science placed Asiatics close to or near Europeans or with Europeans at the top of the scale, and Africans close to apes at the bottom of the scale. Asiatics were indisputably part of the family of man, and by the 1860s, China was formally welcomed into the family of nations as well, as indicated by the signing of the 1868 Burlingame Treaty with the US. Okay, and here Thomas Nast's famous portrait, the youngest introducing the oldest, and we see America introducing China to the rest of the family of nations. Note the absence of African leaders in this drawing, reflecting the widespread view, memorably voiced by Hegel, that Africans were marooned in time with the beasts of the jungle, lacking both civilization and history. The black was indeed the absent referent in white imaginings of the Chinese. It was the not blackness of the Asiatic, as well as their inability to vote, that made them the ideal substitute for black labor, the answer to the problem of slavery's demise. So I suggested that Asian Americans are positioned where the elevating force of not being black meets the depressing force of being not white. Does this mean that they are, in some sense, in between black and white? Not quite. Frank Wilderson writes in Red, White, and Black that in racial slavery, quote, the human was born, but not before it murdered the black, unquote. Anti-blackness, the violent abjection of the black as the antithesis of the human, has structured a social order in which all others, even those despised and unwanted, are at least granted human coordinates. The Asiatics' not blackness got them pretty far in this regard. Negrophobia propelled the Asiatic over the threshold of the human. Oh, I'm missing a page. But once there, they still had to suffer the outrages of white supremacy. They still had to negotiate their humanness with a dominant class who thought of not whiteness as almost a disqualifying trait. Here, Asianness was both an asset to Chinese laborers. It endeared them, for instance, to white economic elites who saw that they could use Chinese laborers both against black laborers and to discipline white laborers. But also race served as the Achilles heel for Chinese laborers. Because, as Alexander Saxton has documented, the Working Men's Party was able to weaponize race in their struggle against what they called the money power, or capital with a big C, in their fight for Chinese exclusion. In the 1870s, as the Chinese exclusion movement began to gather momentum, powered by the fever dreams of white labor organizers and nativist publishers, Chinese humanness posed a sort of conundrum. How could one argue for the exclusion of the Chinese, who possessed legal and international standing, as recognized by the Burlingame Treaty, and who were also manifestly superior to blacks, who were being at least nominally brought into the polity at that moment, right, during Reconstruction? What was the rationale for giving citizenship, voting, and naturalization rights to blacks and not to the Chinese? Okay, these were the questions that really Thomas Nast was trying to articulate with this famous drawing, The Civilization of Blaine from 1879. Okay, here we see depicted Senator James Blaine, Republican of Maine, presidential contender, who was a leading proponent of Chinese exclusion. Blaine, the imposing statesman, is shown physically supporting a diminutive, childlike black man whose fine clothes are at odds with his cringing, servile aspect. The black man tenders a piece of paper that says vote on it to Blaine, who tramples a copy of the Burlingame Treaty under his feet. Importuning Blaine from behind is a Chinese gentleman of upper-class status, arms open, surrounded by the artifacts of Chinese civilizational accomplishment and commercial power. The Chinese man asks, "Am I not a man and a brother?" Echoing the renowned slogan of British and American abolitionists. Nast's message is clear. Blaine is elevating blacks over the Chinese because of political ambition. This is an obvious violation of treaty obligations and racial common sense. So it was under this specific pressure of justifying the demand for Chinese exclusion in the context of Reconstruction that the Chinese had to be made out not just different from whites, but as the most unassimilable people on the face of the planet. It was because Chinese humanness was taken for granted that Chinese foreignness had to be argued with such ferocity. Otherwise, propelled upwards into the category of the human, the Asiatic might be in a position to storm the inner sanctum of whiteness. Here, too, the referent was the black. The exclusionist rhetoric about the Chinese often said the Chinese were unassimilable, whereas black people were assimilable, but it was black people's lack of civilization, their blank plasticity, that made them able to assimilate. So the Chinese had to be excluded not despite their superiority to blacks, but because of it. No force on earth could make a Chinaman an American, but no force could make him a slave either. In 1877, Congress's Joint Special Committee to investigate Chinese immigration held public hearings in California. Here, Senator Henry Cooper of Tennessee questions Reverend Samuel Blakesley, an outspoken opponent of Chinese immigration. Could it, granting the Chinese suffrage, not elevate them? No, sir. The African was compelled to become an American. He became American in taste, American in feeling, American in religion, American in habits, American in morality. Slavery compelled him to do that, but the Chinese never will, as far as human knowledge can tell. Can you not compel them the same way? No, sir. We have got to work on Chinese entirely by moral suasion. You are making the illustration on account of the lack of desire to work with them. Why will not the same remedy apply to laboring men here that applies in the South? And I'm going to skip a little bit ahead. Where you elevate the colored man, does it not do away with that antagonism? It does, but you have already made the colored man an American. Why would it not do to make the Chinaman an American in the same way? You cannot make him an American. Can you not make him a voter? That would not make him an American. The Negro did it not make the Negro an American? The Negro was an American before he was a voter. Okay, let's skip down a little bit, down to this one. There is danger of the South, and there is greater danger with the Chinaman. For in addition, the Chinaman has a vigor of thought that has brought the nation a character, and he believes himself superior. As soon as he would get the vote, he would try politically to become superior, and we should have Chinese judges or Chinese justices of the peace, and they will be controlled by their Chinese prejudices. Would not the Negroes do the same? No, sir. The Negro is an American with American tastes. Can he not be made equally ambitious? Yes, sir, I think so. Why may not the Chinese, after a generation, equally become citizens? Because we cannot reach them except through moral influences. The African was reached through the power of slavery and thus Americanized, but we have no power to make the Chinaman an American. Would not contact with our civilization have the same effect upon the Chinaman as upon the African? No, sir, because the Chinaman despises our civilization. He is proud of his own. He tells us in our face, "You are small potatoes. We were a great nation 3,000 years ago." So blacks were blank slates forcibly imprinted with civilization via slavery. The Chinese possessing human coordinates could not be made into slaves. In an article included in the appendix of the Joint Committee's final report, Charles Wolcott Brooks, former U.S. consul to Japan, observed Negroes, first imported from the wilds of Africa, heathen barbarians in a wild and savage state far lower in the scale of being than the Chinese were 4,000 years ago, for Negroes had no literature, philosophy, or cultivation, were brought here as slaves against their will, with all the horrors of the Middle Passage, to furnish involuntary labor under the lash, a thing no Chinaman will bear. So what marked blacks as slaves, Walcott suggests, was not the mere fact of their enslavement, but that they bore it, as livestock would, because they stood outside the realm of human dignity and honor. Wolcott willfully denies the historical record of black resistance, of slave revolts, fugitivity, black abolitionism, in order to assert slavery is a test of evolutionary fitness. It only happens to those who let it happen to them. For everyone else, it was unthinkable. The Chinese were ineligible for citizenship, but they were also ineligible for enslavement. But what about the coolies? As Moonho Jung has shown in Coolies and Cane, Chinese laborers in the U.S. were persistently associated with coolieism, and through coolieism, with that other form of unfree labor, slavery. So the Chinese were ineligible for enslavement, but the mediating term of coolie brings the two terms into a plausible relationship with one another. The point here is what was accomplished ideologically by positing this association, namely tainting Chinese laborers with blackness and slaveness. As Rudy Batzel discusses, the Working Men's Party in California viewed the large-scale employment of the Chinese as capital's attempt to resurrect slavery in another form in order to undercut white labor once again, right, as the slave power had. So the rhetoric of coolieism allowed the Working Men's Party to mobilize anti-black affect against the slave in the push for Chinese exclusion. But wasn't the Asiatic constitutively not black and not slave? It bears emphasizing that being compared with coolies and slaves did not mean being indistinguishable from slaves. To the contrary, distinguishability is a prerequisite for comparison. Comparison requires difference. We do not compare identical things, X and X, we compare X and Y. It was because they were known to be not black, because they had not blackness to lose, that the slave comparison could be used to tarnish the Chinese. This is apparent if we look at the limit case, Chinese indentured laborers in Cuba. They were technically voluntary laborers, right? They signed labor contracts, they received wages, and the contracts were called papers. Yet there were many aspects of their experience that made them seem unfree, compared, for instance, to Chinese immigrants in California. Lisa Yun, in the book The Coolie Speaks, concludes Chinese coolies were in fact slaves, that their contracts or papers were a mere pretense. But there are many reasons to believe coolies were in a privileged position relative to slaves, from the distinctions made between the two in Spanish colonial law, as you can see in the first box, to the division of work on sugar plantations in Cuba. For me, the most compelling evidence that coolies were not slaves is precisely the evidence that Yun adduces to show that they were, namely the testimonies that coolies gave to the commission that China sent to investigate the coolie trade in Cuba in the 1870s. I don't know how many of you have looked at this testimony, coolie testimony, that was produced by this commission in a report. This is a torrential record of physical suffering and grief, suicide and murder, anger and hopelessness. A recurrent theme in this testimony is the coolies' bitterness that they were being treated like slaves. Again, Yoon reads this as evidence the coolies were slaves. But as Rebecca Scott suggests in Slave Emancipation in Cuba, the coolies' testimony rather shows that they jealously guarded their superior status to slaves. The complaint, we were treated like slaves, should be read as we are not slaves and should not be treated as such. Right? There's an indignation that the coolies are showing at this ontological misreading of them as slaves. Plantation owner Eliza Ripley recalled, the poorest, lowest coolie carried his contract on his person and never hesitated to assert his rights. The fact that the coolies' papers did not mean all they purported to mean does not indicate they were therefore meaningless. Papers did not make the coolie a free laborer, a liberal subject, an autonomous rights-bearing individual. But they were an ontological marker, tagging the coolie as not property, as a being who had to consent to being coerced. This is why coolie traders held Chinese men in barracoons for weeks and even months, beating them and starving them until they agreed to sign contracts. The coolie was different from the slave, not because he was at all times treated better than the slave, but because he was considered a custodian of his own freedom. And so he had to consent to its surrender, even if the consent was obtained through force. So what bearing does this discussion of the 19th century Asiatic have upon the Harvard affirmative action case? What this brief historical detour suggests is that the Asiatic's constitutive not blackness is a form of privilege or advantage that has shaped their insertion into the economy, society, and polity. Thus, it is misleading to say with Justice Powell that Asian Americans are affirmative action spoilers who disrupt the discrimination underrepresentation link. The question how Asian Americans are succeeding despite discrimination, how do they start out in the same place as blacks and end up farther ahead, is not on point. The question should be instead, how have Asian Americans been positioned differently from blacks and in relation to blacks, such that the specific advantages, immunities, and burdens attached to that position shape their group outcomes relative to blacks? This sociometric question undercuts the Asian spoiler narrative by exposing the logical fallacy upon which it rests. In the decades after Bakke, Asian American enrollment in U.S. higher educational institutions rose significantly, surpassing their rapidly growing percentage of the population. As a result, Asian Americans were, in many cases, removed from existing affirmative action programs or not included in new ones. But the Asian spoiler narrative continued with a twist. Instead of being figured as beneficiaries of affirmative action programs who cast doubt on the programs from the inside, now Asian Americans came to be figured as victims of affirmative action programs, casting doubt on them from the outside. In the 1980s, a task force of Asian American activists and scholars noted that Asian American admission rates were not keeping up with Asian American application rates. So they charged a number of elite schools with discrimination. Dana Takagi writes about this in her book, Retreat from Race. But they were very clear that even though they opposed the idea of putting a ceiling or a quota on Asian applicants, they were absolutely supportive of affirmative action, which they understood to be putting a floor right underneath the numbers of other minority groups. So they were very clear about those distinctions, separating the question of a ceiling for Asian Americans from a floor for other groups. However, in the late 1980s, William Reynolds, Ronald Reagan's Attorney General, said in a speech, Asian Americans were victims of affirmative action, and that the ceiling on Asian Americans was the inevitable result of a floor for other favored racial groups. The Asian spoiler narrative was going strong. In Grutter v. Bollinger, the first U.S. Supreme Court case to deal with race-conscious admissions after Bakke, Barbara Grutter, pictured here on the left, a white woman, was rejected by the University of Michigan Law School and filed suit, claiming that the affirmative action program discriminated against her. So in this case, the briefs for petitioner and respondent briefly mention Asian Americans, but I want to focus on the amicus brief submitted in support of Barbara Grutter by the Asian American Legal Foundation, the group I've already mentioned. Again, foreshadowing the arguments that would be made in the Harvard case more than a decade later. So the Asian American Legal Foundation amicus brief in Grutter says that state actors are, quote unquote, have been freed from the constraints of any remedial purpose, are running amok with their racial schemes, arbitrarily designating certain groups as preferred and others as non-preferred, in a grotesque project of Kafkaesque social engineering. What makes the university's program especially repugnant, the brief suggests, is the long history of discrimination against the Chinese. In a perverse sociometric move, the brief implies Asians, already burdened like blacks, are now, because of affirmative action, even more disadvantaged than blacks. There is no mention of historical discrimination against blacks. There's no mention of the integrationist intent of the law school's admissions program. One could be forgiven for wondering if the law school's admissions program was designed specifically to persecute the Chinese. This brief relies upon a highly selective reading of history. Consider how it cites two cases, Ganglam v. Rice, 1927, Lee v. Johnson, 1971, as proof of Chinese Americans' bona fides as civil rights warriors. In the former case, attorneys for Chinese American Martha Lum argued that she should be allowed to attend white rather than colored schools in Jim Crow, Mississippi, on the grounds that the Equal Protection Clause of the 14th Amendment protected the Chinese too. From what? From the dangers of associating with black students. This is an interesting use of the Equal Protection Clause. In Lee v. Johnson, attorneys for Chinese American children in San Francisco argued they should not have to obey a desegregation busing order, because doing so would disrupt Chinese cultural instruction. Chinese Americans fought against racial classifications in education in both cases, it is true, but in ways that reinforced the segregation of black students. Ironically, this is what the AALF is doing as well. A decade after the Grutter Court upheld race-conscious admissions under the diversity rationale, Ed Blum counseled Abigail Fisher, here she is pictured with Ed Blum, a white woman applicant who had been rejected by the University of Texas, to sue the university. Again, I'm going to focus on the amicus brief submitted by the AALF. In the first part of this case, Fisher won. This brief reprises the central themes of the Grutter brief that it submitted with this climactic addition on page 36. Grutter will be seen as the Plessy of its generation. It is worth pausing over this declaration, which likens the Grutter ruling upholding the University of Michigan's Law School Affirmative Action Program to the fateful 1896 Supreme Court ruling that locked down Jim Crow laws for more than another half century. Grutter will be seen as the Plessy of its generation. What we see here is black people being evacuated from their history and Asians moving in to occupy it while trading on the moral currency of the black struggle. Asians are the new blacks. Blacks are not only displaced as victims, they are then vaulted into the position of world historical villains. Blacks and their allies are malevolent Jim Crow legislators. Asian American college applicants are Homer Plessys, courageously defying segregation laws in the name of equality and freedom. And the court's ruling in Grutter is, like the court's ruling in Plessy, a crime against humanity. Asian America first. Liberal Asian American groups like ALDEF, Asian American Legal Defense and Education Fund, and Asian Americans Advancing Justice filed briefs in response to this brief by the Asian American Legal Foundation. The amicus brief submitted by the Asian American Advancing Justice Group notes that, like other minority groups, AAPIs have suffered racial prejudice, and race-conscious admissions programs have helped counteract that prejudice. Currently, the brief asserts select Asian subgroups benefit from race-conscious admissions, all Asians stand to benefit from diversity, and many Asians benefit from affirmative action in other contexts. And as a whole, Asians are not demonstrably harmed by the UT Austin plan. As such, quote, the undersigned amici reject these unfounded claims by petitioner and her amici that AAPIs are harmed by such programs and categorically oppose such efforts to use the AAPI community as a wedge group to curtail racial opportunities for racial minorities. This is essentially the critique of the model minority myth that I commented on earlier. Note how the logic of minority equivalency is reproduced rather than challenged here. Model minority discourse is a non-response to the Asian American Legal Foundation's claim that Asians are the most disadvantaged group. After Fisher's lawsuit failed to take down race-conscious admissions, Ed Blum turned to his Asian strategy and launched the Students for Affirmative Action, Students for Fair Admissions. Their initial complaint in the Harvard case will sound familiar to us by now. Significantly, its second author, William Consovoy, clerked for Clarence Thomas, was second author on the brief for Petitioner Fisher in Fisher 1 and lead author on the brief for Petitioner Fisher in Fisher 2. The complaint calls for the court to prohibit Harvard from using race as even one factor in admissions, and says further, Harvard and other academic institutions cannot and should not be trusted with the awesome and historically dangerous tool of racial classification. As in the past, they will use any leeway the Supreme Court grants them to use racial preferences in college admissions, under whatever rubric, to engage in racial stereotyping, discrimination against disfavored minorities, and quota setting to advance their social engineering agenda. Strict scrutiny has proven to be no match for concerted discrimination hidden behind the veil of holistic admissions. There may be times when social problems can be solved democratically, but massive resistance to racial equality is not one of them. See Brown v. Board of Education of Topeka, Kansas. Once again, the analogy of choice is Jim Crow. The administrators of Harvard's program and their black beneficiaries are segregationist Southern whites, massively resisting integration. Asian Americans are Daisy Bateses, braving hostile white mobs at Little Rock Central High, and the court's mandate, as it was with Brown, is to pursue racial equality in the face of popular opposition. The judge in the Harvard case, Allison Burroughs, may not pass judgment on student for fair admission's perverse sociometry and fantastical analogizing. Instead, the case will likely turn on the technical question of whether Harvard discriminates against Asian applicants in its personal ratings, which are one component, along with academic, extracurricular, and athletic ratings, of each applicant's overall score. In personal ratings, applicants are assessed on traits such as positive personality, others like to be around him or her, likability, helpfulness, courage and kindness, attractive person to be with. Asian Americans are consistently given lower personal ratings than other groups by Harvard admissions officers, which lowers their admissions rates. So the question is whether this is a result of discrimination or non-discriminatory factors. So a student for fair admissions expert says his statistical analysis shows this is discrimination at work, and that Harvard engages in what he calls racial balancing to give Asian American applicants lower personal ratings, which lowers their admissions rates. Harvard's expert disagrees, saying personal ratings are too complex to be modeled statistically because they involve multiple components that are statistically unobservable or impossible to measure. He notes that the Asian American percentage of the admitted Harvard freshman class has increased by 29% over the past decade to now nearly 23% of the freshman class, keeping in mind that Asians are less than 6% of the US population. Will the judge accept the student for fair admissions claim that the disparity in personal ratings proves intentional discrimination, or Harvard's claim that it is the innocent result of a combination of statistically unobservable factors? Whatever the outcome at the district court level, will students for fair admissions at subsequent levels of review persuade the courts that a ceiling on Asian Americans, if it does exist at Harvard, is inextricably tied to a floor for other minorities, and that therefore the court should prohibit the consideration of race altogether in admissions? It remains to be seen whether the Asian spoiler narrative will accomplish what white charges of reverse racism have for decades not been able to accomplish. That is the ending, the final dismantling of affirmative action in US institutions of higher education. In Jordan Peele's acclaimed 2017 film Get Out, the sole Asian character, a man of Japanese descent, Hiroki Tanaka, attends the cocktail party thrown at the Armitage House. Hiroki is on the far right there. He approaches the protagonist, Chris, at one point during the party and asks if being African American is an advantage or a disadvantage. This is Hiroki's only line in the film, and it is a surprising line, to say the least, in a film whose subject matter is anti-Blackness. Tanaka then goes on to make a formal bid, alongside the white guests, for the use of Chris's body. What does it mean that an Asian man asks this question of a black man in the middle of what turns out to be an extended slave auction? What does it mean that he imagines being black could be anything but a disadvantage in this context? One way to read this scene is to see it as a commentary on how Asian Americans show bad faith when they insist on minority equivalencies and deny their relatively advantaged position within an anti-black order. When Hiroki asks the question of Chris, he is not so much seeking an answer as performing a refusal to acknowledge the anti-Blackness that structures the world. He dissembles his own racial status even to himself. He wonders if he has it worse than a Black man, even as he prepares to bid on that man's body in an auction and, if all goes well, occupy it in perpetuity. What Peale invokes so powerfully here is the fraught question of Asian American involvement in and investment in an anti-Black order. Sometimes Asians are not unwilling conscripts or pawns in white racial games. Sometimes they weaponize themselves. The Harvard case is one such moment. My hope is that this moment will be a turning point where we Asian Americans look back and say, that was the moment when we began to develop a new sociometry of race. Justice Powell was right that sociometry is a difficult and contentious task, but as he himself demonstrated inadvertently, it's not a choice between sociometry and no sociometry, but a choice between one that is covert and unsubstantiated and one that is open and transparently defended. We are all sociometrists, and we always have been. The question is whether we will allow to stand a sociometry that dissembles existing structures of racial power, or instead produce one that names and analyzes these structures and exposes them to the light, however uncomfortable or unsettling the sight. It's not enough to say we are not that successful, or we are discriminated against too, or even to say we will not be used. The language "we will not be used" suggests that Asians are hapless pawns, unwilling conscripts, when the truth is more complicated, that we have been not Black from the start, with all that this entails about psychic and material investments in the social order. How then can we grapple collectively with this truth and reimagine ourselves, not simply as victims, not always as protagonists, and rarely as innocent? How can we complicate the story of our own suffering profoundly and irrevocably by seeing it in relation to Black suffering, whose limitlessness defines the limits of ours? For those of us who dream the dream of Afro-Asian relationality, the story is, at least in part, ours to write. Thank you.
Produced by Duke University.